All right. Good morning and a very warm welcome. Here at the EPC, it's a pleasure to welcome a full room. So many of you, both here in the room, but also online. I know we have quite a few participants in our online audience today. This will be a very hybrid event today. Yeah, it's a pleasure to welcome you, all of you here at the EPC for this policy dialogue on the rule of law beyond the EU member states, organized jointly by the EPC's Connecting Europe project and the Rule of Law Clinic at the CEU Democracy Institute. My name is Johannes Greubel. I'm a senior policy analyst here at the European Policy Center, and I'm leading the Connecting Europe project. Connecting Europe is a joint initiative of the EPC and Stiftung Mercator, established in 2017 already. We're a network of around 60 civil society organizations, research institutes from 15 European countries. And the project has the objective to connect civil society with EU decision makers here in Brussels, and in that way to transnationalize policy debates here in Brussels. So what we do is provide a platform for dialogue, for a space in which civil society, academia can showcase, advocate for their ideas. And yeah, in that way, our objective is to foster an open, constructive dialogue between all of these actors here in Brussels. With events such as this one today, I'm more than delighted to have the CEU Democracy Institute here today, who will present this morning their news publication, a Shadow Rule of Law report, published by the newly created Rule of Law Clinic. It's a brilliant analysis of the state of the rule of law in the union level. And I think it's a very timely moment to discuss exactly that, as we are at the start of a new political institutional cycle. Yeah, including also the chance to discuss the rule of law and the rule of law report, as Commission President-elect von der Leyen in her new political guidelines has talked about the success of the report in the past. We will certainly discuss about this in the discussion today, and also pledges that there is need to consolidate the report and build on it. Also, Commissioner Designate McGrath, in his written answers, already highlighted ahead of the hearing in the Parliament to strengthen and consolidate the report even further, including through a closer link to EU spending and by enriching the reporting cycle. Still, the union dimension is missing, and that is what we want to discuss this morning. Without a further ado, I will kick off our event. We will start with a video message of Commissioner Didier Reynders, outgoing Commissioner of Justice, before handing over to Dimitri and Barbara for a quick introduction of the Rule of Law Clinic and the Rule of Law the Shadow Rule of Law report, before then starting an interactive discussion with the panel, which I'll introduce later. Looking forward to the discussion, but first of all, let's listen to the words of Didier Reynders.
Dear participants, good morning. It's my pleasure to address you to open this exchange on the state of the rule of law in the European Union. The Commission's annual Rule of Law report is a well-established instrument to monitor the rule of law situation in all EU member states. It is true that we do not assess our own rule of law performance in the EU institutions in our report. A self-assessment could be seen as not credible. I therefore welcome the initiative of the Shadow report, providing an external view on this question. Upholding the rule of law is essential for the EU to function effectively. Here, I recall that the EU institutions are under the control of the Court of Justice, which ensures that EU law is observed and that the treaties are correctly interpreted and applied. Its decisions are binding on all institutions. But having an open exchange about the rule of law situation at EU level can contribute to the overall legitimacy of the EU's actions to uphold the rule of law. As my mandate comes to an end, it is good time to reflect on what we have achieved in the past 5 years and what lessons we can draw for the future development of our rule of law toolbox. I know you also consider this in your shadow report. The Commission has several well-established rule of law instruments at its disposal, and these have been successfully applied in many instances. For example, the annual rule of law report has systematically and objectively examined rule of law developments in all member states since 2020, achieving key objectives. Member states and the European Union overall are much better prepared to detect, prevent, and address emerging challenges. Around 2/3 of the recommendations issued in 2023 have been followed up fully or partially, showing important efforts are being made to address the recommendations. One example of this concerns Spain. Following a structured dialogue with the European Commission as facilitator, an agreement was reached by the two main political parties to renew the Council for the Judiciary, which was a pending issue since 2018. We have also taken decisive action where necessary. First, the Commission has launched several infringement procedures to ensure effective judicial protection by independent courts, leading to the further development of the Court of Justice case law in this field. Second, national recovery and resilience plans for 16 member states have included 74 reforms and investments in the field of justice, with relevant investments amounting to approximately 3.4 billion euro. These reforms are now being implemented and are producing concrete results. Third, applying the budgetary conditionality regulation in the case of Hungary has led to the Council to suspend 6.3 billion euro in budgetary commitments to protect the Union's financial interests. Looking to the next mandate, the political guidelines cement the rule of law at the heart of the successful European Union. The rule of law report will continue to spearhead this work and will be broadened to include a single market dimension, looking at issues affecting companies, especially SMEs, operating across borders. The Commission will also establish a closer link between the rule of law and its recommendations and funding under the EU budget. This will be an important consideration as we are determined to ensure that the next multi-annual financial framework delivers the maximum benefit to European citizens. Moreover, enlargement countries will be included in the rule of law report as and when they are ready, based on the criteria established this year. Finally, enforcement will be crucial. Tracking the implementation of the report's recommendations will be developed as a way of consolidating the report's progress. This is just a brief look at our next plans. I'm sure that the findings of both the shadow report and our rule of law report will inspire interesting discussions. I'm looking forward to hearing about the results. Thank you.
Thanks at this stage also to Commissioner Reinders for this video message, although he could not be here with us today. A video message which also looks back at a Commission assessments of what has been achieved in the past years. And many of the things that Reinders mentioned, you will recognize are also discussed in one form or the other in the report, in the shadow report. So time to find out more about the Shadow Rule of Law report, and I'm happy to introduce you to two of our guests. On the one hand, Dimitri Kochenov, a professor of legal studies at the Central European University in Vienna. He leads the Rule of Law work group at the CEU Democracy Institute and is also co-founder of the CEU Rule of Law Clinic. Dimitri will present the project in a few minutes, and right after, we will hear from Barbara Grabowska-Moros, who is director of the Rule of Law Clinic at the CEU Democracy Institute and also senior research fellow there. She will present the main findings of the Shadow Rule of Law report with you in a minute after Dimitri's remarks. So please, Dimitri, over to you.
What an honor to be here and to fill this gap in our rule of law assessment. So, what is the rule of law clinic? To remind you, the case that the Commission won against Hungary still resulted in the exile of the Central European University from Hungary to Austria. We are prohibited from teaching in Hungary, one of the member states of the EU. So in order to remain present in the country, the university decided to put some research institutes in the Hungarian capital. And what we focus on, among other things, is democracy and the rule of law. So the clinic, which deals with rule of law research and rule of law implementation, and which was founded with the general support of Stiftung Mercator, is aiming at giving the rule of law a voice. We bring third-party interventions in front of the highest courts, and we try to fill the most obvious gaps in rule of law assessment and the rule of law performance in the European Union. Until today, the European Union has never received any kind of assessment of its own rule of law performance. And this is precisely what we focus on. Why is it necessary? It's not only purely theoretical. Of course, theoretically, you can say the European Union, in order to be credible, should apply the same standards as the standards that it advocates for the national level. But the Mediterranean is also a mass grave. And Frontex also shares data with the criminals funded by the European Union in Libya. We have problems with European arrest warrant implementation when people presume criminals are sent to places where they will not face independent justice. We have problems with the implementation of European Union rule of law conditionality when nothing changes in the countries which are subjected to it. So plenty of things are to be highlighted, and this is exactly what we try to do in this flagship instrument, which will be an annual publication and which I'm happy generates some interest. Thank you so much, ladies and gentlemen.
Thank you. Good morning. I think Dimitri just made my task much easier because he basically mentioned all relevant elements which we wanted to tackle in the report. Together with the experts on the EU, we decided to present the state of affairs when it comes to the EU rule of law situation. And this is because the EU became a really important rule of law actor in the recent years. At the same time, its flagship instrument, meaning the rule of law report, was still missing one of the most important chapters, the chapter about the EU itself. And we believe, and this is a result of the report, that without such self-assessment, but also independent outside assessment of the EU, it might undermine the credibility of the EU position as the rule of law actor in the current situation. So the report follows the same structure as the Commission's report stands for. So we start with the judiciary, and we find out that the limited access to the court might result in making some of the EU decisions and actions being unaccountable and left behind without any judicial review. EU accession to ECHR, so one of the biggest rule of law treaty obligation, has not been fulfilled so far. And we're still trying to figure out what can be done and what should be done in order to implement and introduce this important limitation to the EU actions. In judicial cooperation, there are cases when mutual cooperation prevails over naming and assessing the systemic rule of law backsliding. Then moving to the anti-corruption framework, it turns out that the existing legal framework is extremely complicated. At the same time, the scandals such as Qatargate brought up again the questions about the effectiveness of the EU anti-corruption framework. In the media freedom field, important improvements have been recognized, such as adoption of European Media Freedom Act, Anti-SLAPP Directive. At the same time, within the last 14 years, there was just one infringement case dealing with the media freedom that reached the Court of Justice. So the same with those two new instruments, the oversight, how Commission is checking the implementation of those instruments will be absolutely crucial for the second edition of the report. And that brings me to the key element of the report. So EU actions which are aimed to defend the rule of law at domestic level. We believe that Commission's enforcement record is insufficient in terms of the rule of law cases. At the same time, politicization of the rule of law procedures seem to be the major threat to credibility of the EU rule of law policy. Finally, and I think the most serious rule of law concerns we diagnosed deal with the migration management. So leaving Frontex outside any judicial review or oversight is in one example, but the same is with the EU funding. Those seem to be the areas which are not countable to law. We believe that this first edition of the rule of law report is a step in a process which is aimed at strengthening the EU credibility and making the EU a stronger actor in the rule of law policy. Thank you.
Thank you, Barbara. This is already very insightful and so much to follow up from already. But I leave that to the brilliant panel that we have lined up for you today, which I now have the pleasure to introduce you to. We have, on the one hand, joining us online, Tineke Strik, member of the European Parliament for the group of the Greens and member of the Libe Committee, who will be joining us online, and hopefully we can see her in a second. A few weeks ago, she was also appointed the European Parliament's rapporteur on the Article 7 procedure concerning Hungary. Our second panelist will be Michal Warwieckiewicz, member of the European Parliament for the European People's Party and also member of the Committee on Legal Affairs. Welcome. Great to have you here today. We will have Laurent Pech, who is a professor of law and a dean of the UCD Law School and also co-director of the Rule of Law Clinic and senior research fellow at the CEU Democracy Institute. Welcome. We have Petra Bart, research affiliate at the CEU Democracy Institute and professor of sustainable rule of law at Radboud University. And last but not least, I have the pleasure to introduce you to Joelle Grogan, academic co-director of the Rule of Law Clinic and senior research fellow at the CEU Democracy Institute, who will moderate the panel discussion with you now. And I can ask you all panelists to join Joelle at the panel, and I'm looking forward to a great discussion.
Considering at my wedding, I didn't get to walk up an aisle. That was the most dramatic entry I think I've had. I am delighted to be here moderating this fantastic panel, marking the launch of the very first shadow reports, this missing chapter analyzing and considering rule of law at EU level. I am very grateful that I don't need to introduce anyone, and forgive my Irish accent. I will be very self-conscious pronouncing every name. but I have practiced saying the European Union a few times. What I would say just in terms of the panel ahead of this, I'm pushing it for it to be as question-based as possible. I have a few initial questions to each of the panelists, but then we are going to turn it over to the internet and also those here in the room. For those listening to us online, I have no idea where the camera is, so I'm going to look out into the ether. For those listening in online, please do write your questions in. We have Vox Populi, the voice of the internet, over here in the form of Johannes, who is going to read out those questions. What I'd also say is I am going to assume authoritarian, if not dictatorial powers in cutting off anyone who offers an opinion, not a question. So as soon as you start speaking, and you will be speaking into a microphone, so again, the people of the internet can hear you. But if you start speaking longer than 10 seconds in my head, I will cut you off very dramatically. Let that be a warning to everyone out there. So on that wonderful note, I'd like to ask a first few initial questions to the panel. I'm going to begin with our two professors who are also contributors to the report. So Laurent, taking a bit of a devil's advocate stance, why on earth is something like this needed? Surely rule of law is protected already at EU level.
Thank you, Joelle, and it's a pleasure to be here and to have contributed to this what I used to call the missing rule of law chapter, because as you know, we have a rule of law chapter dedicated to the situation in each of the 27 member states, but there is the missing chapter, the one about the rule of law at the EU level. Now, why should we need such a report? I mean, it reflects actually just a very basic idea, which is the rule of law not simply binds the EU member states, but the EU institutions themselves. So that's the idea underlying the report. And when it comes to assessing compliance with EU rule of law requirements, so we have many mechanisms, including this annual reporting mechanism, but the EU has refused or has been reluctant to engage in any serious, meaningful self-assessment of its own performance, even though the EU itself is subject to strict treaty obligations, not only when it comes to acting internally, but also acting externally. We tend to forget the external dimension quite often when assessing the EU's rule of law performance. This report does both, so it looks at both the internal performance and the external performance, or the lack thereof. And why is such a report needed? Because the EU is not the typical international organization. It has massive legal and financial authority. It can adopt directly effective rules with primacy effects. And in terms of financial clout, it's not simply about legislation, whether EU legislation complies with EU rule of law requirements, but it's also about how do you use financial instruments. It's also very important to assess the EU's performance because it directly impacts the national performance. And the EU can influence this in two ways. And I'm going to conclude very quickly because I can feel the weight of your eyes on my neck. So I would say the EU can also dramatically impact the rule of law situation at member state level in two ways, either by essentially pretending that the rule of law situation at member state level is fine, so through a kind of a possibly inaccurate assessment of the situation. But I think also we don't pay too much attention yet about when the EU does not act and the indirect impact it has on the rule of law situation as well. So for instance, when the Commission is not bringing infringement actions when it should, and then raising, in fact, not only legitimacy issues, as Barbara was saying, but also consistency issue, and just overall the kind of the credibility of the EU as a rule of law actor can be questioned. So I think this is why this report does feel a big gap in the current toolbox. And to conclude, I would just like to credit actually MEP for essentially inspiring us into producing this report. Petra and I actually have been working with Sophie in Vell for many years. And I think, as far as I know, she was kind of the first MEP, or one of the first MEP to suggest that there was a missing chapter, the EU chapter. Initially, the thinking, according to Sophie in Vell, was to subcontract this report to the Venice Commission. I don't think it was done. So then we took the initiative of filling the gap by ourselves. So thank you.
You could see me counting down in my head. Professor Bard, I'm going to be very formal. Professor Bard, this report highlights some quite serious, if not severe, issues at EU level. Couldn't you say that this is actually undermining the cause? We're giving further ammunition, further credibility to those who say double standards, who accuse the EU of acting while not holding itself to its own standards.
Thank you very much for the question. And indeed, this seems to be a risky move, a risky enterprise that we are doing in the framework of this EU chapter for the annual rule of law report. But let me give you 3 arguments in favor of making this exercise. So first, let's talk about media landscape. In some member states, the situation is so grave that there is a total media capture. Now, of course, there are outlets in these countries where facts or truth becomes a mere suggestion. So irrespectively of what we write in the report or what the Commission writes in the report, and in fact, irrespective of whether it has an EU chapter or not, there will be reasons found, whether they are justified or not, to criticize and scapegoat the European Union. So basing our decision on whether to have this EU chapter or not is like making dinner plans based on a very picky toddler's choice. No matter what, they will find a reason to complain. So there is a second reason for the report as well. So what does it actually contain? Corruption in the EU institutions. This is hardly a groundbreaking news. Or death at the borders. Yes, this is horrific, but it's very well documented. Or the fact that mutual recognition doesn't really work. I mean, maybe this might sound like a niche topic, but defense lawyers all across the European Union know better than anyone else that this is really the truth. So we only kindly ask the institutions to honestly face these issues and to actually counter them and just have a commitment for action. So this is all we ask for. And this really isn't a scandal. This is an invitation for self-improvement. And then I have a third reason, and probably this is the most important reason, that it would show the importance of accountability and credibility of the European Union. It would also show that the European Union does not shy away from scrutiny. It would also show that the European Union is not using double standards vis-a-vis the member states and its own institutions. So it would show that the European Union has an autonomy. This might sound a little counterintuitive, but giving up a little bit of its autonomy, for example, in the framework of EU accession to the ECHR, which should have happened a long time ago, is actually strengthening the remaining autonomy. So I would say that self-scrutiny is not self-sabotage, but much rather it's a statement of integrity and trustworthiness. Thank you.
Thank you, Professor Bard. We turn now to our members of the European Parliament. We're very grateful for coming and joining this panel. I'd like to first ask Ms. Strick, why do you think it's important that the EU advocates for the rule of law, not only within its member states, but also at EU level, within EU institutions?
Well, I think, first of all, I'm really thrilled about this report regarding the external cooperation on migration. I also wrote an article about this, how the EU itself adheres to the EU treaty principles. And indeed, it should be consistently adhering to it through all policy areas. On the one hand, because the EU needs to lead by example, I think also to show to the member state how it should apply and adhere to the principles and obligations. But also the EU is a political union on its own. It's based on the obligations to promote and to ensure democracy, rule of law, fundamental rights. And if you look also at Article 13, it's also clear that, you know, there is a separation of powers, that there should be an institutional balance. So I really think it's key that we assess that in a very, let's say, neutral and open way. And what I really don't understand that Mr. Reinders said, that self-assessment would promote a lack of credibility. I really see it the other way around. I mean, it would be much more self-confident to be open to really analysis if we adhere to the obligations or if not. Only then I think we are a credible performer towards the member states as well, and we would also be credible to our citizens who should be able to count on the protection by the EU.
Thank you. Before I turn to that last question to Mr. Vabikiewicz, I would like to remind everyone out there in the ether, also known as the internet, please do ask questions. You have a voice in the room. And also for those in the room, please prepare your questions now. And remember, I have 10 seconds counting down in my head. But let's turn finally. What issues would you identify at EU level in terms of the rule of law, both in its monitoring and its enforcement, but also within the institutions themselves?
Well, thank you, first of all, for the kind invitation for this fascinating debate, which is really indeed. I think that I'm not ready to answer clearly on that question, if it is a good idea or not, to prepare the whole process of accession of European institutions. And I think what Barbara Grabowska-Moros stated is the best description of this issue, which is that report that you already prepared is a good step towards the process of assessing of the European Union institutions' performance. I look at this issue from the different angle, because I was present here in Brussels for last 2 terms as a representative of NGOs and independent expert, and also the representative of Polish judges and justices of the Supreme Court in front of the European courts. So that was a little bit different angle. And now, as a member of the Parliament and as a member of the European institutions, I look at these topics from the different perspective. And what I can see right now, that if I am together with Tineke, shadow rapporteur for the Article 7 procedure in Hungary, and also shadow rapporteur for the rule of law report prepared by the Parliament as an answer for the rule of law annual report of the European Commission, I can see that this is the role of the Parliament, European Parliament, to control European Commission. So this is the way of assessing of the European Union institutions when they control each other. As a member, when Parliament controls the Commission, and on the other way. But when I look at the process, actually, such a fundamental violation of the rule of law is relatively new experience for the European Union. It's the experience of last 2 terms, actually, because what started in Hungary and then in Poland, that massive process of the violation of the rule of law, was unknown before in such a scale. So what European Union, especially Commission and the Council, experience throughout last 8 years, it also relates to the Court of Justice, of course, and the case law of the Court of Justice. It's a completely new issue. So this is the moment when we can, after these 2 terms, look at what the European Commission did in that respect, and we can start the debate and the discussion whether the toolbox that we have in our hands is enough efficient or not. I think that we'll have an interesting debate with Laurent, because as far as I know, he's at the position that the toolbox that we have, that the Commission has in the hands and the Council has in the hands, is enough, but we need to, they need to perform it in a more efficient way. But I am also at the position that we need to start a debate how to improve that toolbox. And when we are looking at the toolbox that we have right now in the hands, we can assess if the steps which were performed by the Commission were enough efficient or not. When we are looking at a Polish example, some of the infringement procedures which were proceeded against Poland did not have the motion for the interim measure, and some of them had. And that is the fundamental difference in the effectiveness of the tool. If the Commission filed the motion to the court for the interim measure, and if the interim measure was issued by the Court of Justice, then the whole process of the counteract against the violation of the rule of law was much more efficient. So right now we can think about these factors, and we can debate if the Commission should, in every moment when the violation of the rule of law is such dramatic, like it was in Poland, or it is still in Hungary, or in Slovakia, if they should explore this instrument or not. In my opinion, they should, each time. We have a good example right now in Hungary, when they started infringement procedure just recently, but they didn't file the motion for the interim measure. And it is completely not effective, because the new act, which is violating the European standards openly, is still in force. And we can expect the ruling of the Court of Justice within the next 2 years. And still, during that time, the law, which is effective still in Hungary, will violate our common European standards. So this is the example why we should definitely discuss about this topic, if all of these procedures should or not be proceed equally to each member state and to each case. Thank you.
Thank you. With those opening remarks, I'd like to turn to questions from the... sorry, that I saw something. Yes, of course, Tineke, can I turn over to you?
Thank you, Joelle. Yeah, I did not yet dwell into the topics, but can I mention just a few issues that I think are most problematic?
Please.
Okay. No, because Michel is completely right on the rule of law. There's still too much of a, let's say, discretion, or maybe also political consideration on when the Commission uses its enforcement power. And it also isn't transparent in the way that it does, and it doesn't involve the Parliament, for instance. But I think also, if it comes to legislation, the Commission often omits the obligation to do impact assessments, so that we also see in a transparent way what is the problem, and will this new legislative proposal solve the problem, or what may be the effects of it. And with the Migration Pact, or with all migration instruments, there's no impact assessment at all. And at the same time, no implementation reports, although this is an obligation in the separate instruments. So what we are really lacking is transparency in the way the Commission deals with its task to come up with legislative initiatives. I have the impression it's more and more listening to the member states and serving their interest, instead of serving the communitarian interest and coming up with with proposals that make sense. But I think indeed the biggest problem is the enforcement problem. And on rule of law, indeed, we see a lack of consistency and urgency. But on migration, there's actually no enforcement at all, I must say. There is, which leads to an atmosphere of impunity, where first the pushbacks were more or less hidden and more incidental. They have become a very clear, open and structural practice exercised throughout all the member states at the external borders. And they know they are not going to be bothered by the Commission. And I think this is maybe also due to the fact that enforcement is so much subject to political consideration. It's a decision made in the whole college, And we know that also member states exercise a lot of influence on whether or not an enforcement action will take place. And I think this is a really fundamental deficiency in the whole institutional framework. I think if it comes to enforcement, it should be based much more on an independent and neutral basis. This is difficult in the current framework, but at least maybe the Commission should try to disentangle the different roles that it has. And my last point on the external dimension, there it's really clear that the whole Article 21 promoting democracy, fundamental rights, and rule of law is completely being undermined by the own performance of the EU, where it puts conditionality only in relation to border control instead of to adherence to fundamental rights and democracy, with really a very harmful effects, I would say, in Tunisia, Libya, Turkey, but also where it, deliberately puts aside the Parliament and the Court of Justice. And I wrote a report in the previous term on the human rights aspect of the external dimension of migration cooperation, where we pointed at all those shortcomings, that there should be human rights impact assessment beforehand, and there should be independent monitoring, there should be a suspension mechanism and transparency on the budget, and of course a role for the Parliament and the Court of Justice. So the Parliament adopted this report, but because of we are sidelined, I mean, there was no follow-up to these calls as well. And I hope that litigation will do something with this, but it really makes the EU undermining its own credibility, that at the EU level, all these key principles are being undermined on a daily basis.
Thank you. Thank you. We certainly have raised a lot of very important questions with regards to the accountability of EU institutions, the enforcement of law, frankly, and also larger questions of the politicization so much of rule of law actions within the EU. I will now turn to questions from the audience, but I'd like to first start with the internet. Johannes.
I'm not talking of myself, but as the voice of the internet, as mentioned, as we have not only a full room here, but also around 80 people following from online. And there's also questions online, 3 questions that I wanted to pose to the panel right now. First question by an anonymous attendee. How do you see the EU performance in terms of checks and balances beyond the media? And then 2 questions that are connected to the external role. Do you find that internal rule of law deficits within the EU also undermine its credibility vis-a-vis international partners? For example, when trying to engage in external democracy promotion? And then a second question that is connected to that from Raf Kazat. Hi, if we look at the example of Georgia, how could the voice of the EU be strengthened when it comes to rule of law issues or even election rigging?
Thank you. I want to almost immediately go to Petra on the first question. I was a little bit inspired. Petra, can I turn to you on that?
Yes. Yes, thank you very much indeed. Well, we have dealt with the institutional balance in the sphere of the rule of law, obviously. It is a rule of law question itself, how the institutions relate and check each other. But at the same time, the institutional balance within the rule of law enforcement is a very, very important topic as well. What we have seen is that there still is a democratic deficit, if I may say. And part of the reason for the inefficiency or lack of dissuasiveness of certain rule of law tools, such as Article 7, is the fact that the Parliament still doesn't have a sufficiently especially important role. So, for example, in case the European Parliament initiates an Article 7 procedure, as it happened against Hungary, the Parliament has much less roles than the Commission, whenever the Commission initiates such a proceeding. So I think that there should be an equality between the institutions guaranteed, not just because of checks and balances and the imbalance in powers, but for the sake of rule of law enforcement as well.
Thank you. Tineke, if at any stage you could wave at me, I now have so many screens with your fabulous face, so I will absolutely know. But would you like to add a few points on just this first question?
Well, on the external dimension, maybe, or do you want me to say something on the media?
We will turn to the international dimension in just a moment, but if you have passionate feelings about talking about media dimension, we can pause there for a second.
Well, yeah, I think we were quite late in the EU to come up with a Freedom Media Act, for instance. And when I visited Budapest a few weeks ago, the journalists already said to us, like, for us, it's already too late for the Freedom Media Act to do something about the lack of independent media in Hungary. So it's clear that we must really make maximum use of the tools. For instance, also the competition law, which might be an important angle also to use. I'm not sure if they also mean the media at the EU level, but I think it's more like, the need to really make sure that not only the Media Freedom Act is fully implemented, so that it's really also enforced where it's not implemented, but also go beyond that legislation, I would say, because you see it everywhere in the playbook. Media is the first one to be attacked. And it should not always only be a matter of enforcement, but also the promotion, I think, of people who do investigative journalists, who want to work in an independent way, to see in what way the Commission can also support them, including civil society.
Thank you. We have two very important questions that are interlinked, and I will be turning to my right first on the credibility of the EU in terms of its international partners as a promoter of the rule of law, especially in light of the Georgia elections. Can I turn first to my right?
The short answer is yes, definitely. European Union institutions are responsible for the promotion and credibility of our common Europe outside our borders. And as far as the European Commission is responsible for guarding the rule of law on the territory of the European Union, it is also responsible and accountable for protection against any violations, any undermining of the rule of law inside the European Union. So when we are looking at the process of democratization in, for example, in Georgia, in Moldova, in other countries, we should promote the rule of law inside the European Union to be able to somehow influence the external territories of the European Union. So when we look again at the Polish situation within the last 8 years, we can see that in some, even if the whole story was successful at the end, even if we were able, thanks to the European institution and thanks to the engagement of the European Commission and the Court and the Parliament and the Council, that we were able to liberate from this authoritarian path, but still some of the areas inside our country within these last 8 years were not covered properly by the European institutions. I mean, the first good example is the Constitutional Court in Poland, which still exists in the same performance as it was 8 years ago, and it's still functioning in the violation, in the permanent violation of the European standards. So if my answer is, if the European Commission was fast enough at the beginning, if they recognize these red flags at the beginning, that they would be more efficient and they should be more efficient at the beginning. So this is the experience for the future, that the European Commission and the other institutions, also the Court of Justice, should recognize any problem of the violation and undermining the rule of law at the territory of the European Union very fast, firmly, and react very quickly and firmly. And that is also the whole strategy of promoting the rule of law outside the borders of the European Union. Thank you.
Conscious of timing and really wanting to get as many questions as we can from the audience, I would like first to turn to Tineke, and then I will turn to questions in the audience. Tineke.
Yes, briefly, because I'm dealing with enlargement as well, and I think that there the EU could really make better use of the accession process and prioritize rule of law and democracy in that process. And what we saw in Georgia, is that, of course, quite soon after the candidate status, this foreign agent law was being adopted, which led to an immediate decision by the EU to also freeze the funding. And I think on the one hand, it was also good, that you are consistent saying, look, accession process means progress and strengthening rule of law and democracy and fundamental rights. And we're not tolerating any backtracking on that. On the other hand, it did not work well in Georgia, where we look now at the outcome of the elections. And I'm not sure how to do that. Maybe there the EU, apart from being consistent in conditions, it should be, I think, also invest more in promoting civil society and the pro-reformists in those countries, strengthening them, and also be very loud and clear in those countries, like what are the benchmarks, what is in it for the citizens, in order to promote and support the accession process and also reforms that are necessary for that. Sometimes this is lacking, and where you saw in Georgia that, the Russians do not shy away from all these disinformation and the use of media, where the EU is much more silent. And what I also see in the Western Balkans is that rule of law is not always prioritized in the accession process, but own interests like migration, returns, or we had an Hungarian commissioner on rule of law on enlargement, which was actually more serving the Hungarian interest and also supporting divisive policies like from Fujic and Dodik. So I really hope with the new commission, there will be much more consistency. And my last point on the external dimensions, what I just wanted to make the point is that, the way that we are dealing with autocrats in order to promote our own migration agenda, with Said, with Sisi, with Erdogan, all autocrats or criminals like in Libya. We leave civil society and all the institutions completely out in the cold. They are persecuted, they are in prison. And when I asked EU, what are you saying towards the dictators? Nothing, because they are very afraid that they will undermine their own interest, namely the border controls. And this is really what undermines, the complete effectiveness of Article 21 of the treaty. And in the end, actually, I think only leads to more refugees, because you see that more people need to flee their countries. And it's, of course, also promoting destabilization of this region. So as long as we have migration priority number one in our external agenda, this goes really at the cost of promoting rule of law, democracy, and fundamental rights.
Thank you. Thank you. Questions from the room. I would ask you also introduce yourselves first, and 10 seconds will be counting down in my head. Could we first go to the very back of the room, and we'll take questions in groups of 3.
Monica Stensland, Norway's mission to the EU. Thank you first for a great panel. My question is, I would like to hear you elaborate a bit on what you would like to see at EU level going forward in terms of measures and initiatives to strengthen and protect civil society in EU member states. Thank you.
I think there was a question here. Hello.
Good morning, my name is Mark and I'm a human trainee at the European Parliament, and I would like to ask Professor Pech about the potential you see in the Fundamental Rights Agency to maybe draft in the future this missing chapter in assessing internal EU rule of law performance. As a follow-up on that, to the MEPs in the panel, would you see that politically feasible at the EP level to task the Fundamental Rights Agency with this chapter? Thank you.
There we go. And continuing to the third row first, and then we'll come to you next.
Yavuz Aydın from Justice for Rule of Law, once a judge in Turkey and now a refugee here. So my question pertains to migration and asylum related issues. And I want to thank these great people of Rule of Law Clinic for touching upon this migration and asylum and this problematic aspect at EU level, emphasizing that this creates, the externalization creates this untouched and lack of judicial review. But for the member states as well, do you think there should be a chapter for each and every member state to review their performance of rule of law regarding the asylum and migration related issues, which is the core of the politics of all member states now, apparently? Thank you.
Thank you. We have 3 questions there. The first going to, well, what should we do, especially in the context of civil society? I really think this should go back to Tineke and also to Petra. But Professor Pech hasn't spoken yet, so I'm arbitrarily going to go to the second question first. Fundamental Rights Agency, never heard of that one before.
I'm not complaining. I'm having a nice time avoiding the most difficult questions. I'm quite happy to answer the question about the EU Fundamental Rights Agency. So yes, it's one of the suggestions, in fact, Joelle and myself made a few years ago, that possibly the EU FRA is underutilized in the EU's institutional system. There are legal reasons for that, and essentially the member states, and I would say to some extent the Commission, have been reluctant to expand the jurisdiction between quotation marks of the EU FRA. I think there is untapped capacity, however, and arguably, you would need to change the regulation on the basis of which the EU FRA is organized to give the FRA, for instance, jurisdiction to look at EU's external action. So still, there is a lot more which can be done by the EU FRA in the context of Article 7, for instance. There is nothing preventing the Commission from relying on EU FRA. The Parliament, looking beyond the Fundamental Rights Agency, the Parliament has been asking for a panel of experts to also work with the Commission regarding the annual rule of law report. Now, there are reasonable arguments as to why the Commission would be reluctant to work with a panel of independent experts, but I would hope that the Parliament, I think on its own motion, could set up a panel of experts to work with the Parliament, reviewing actually the output of the Commission's annual rule of law report. At the risk of contradicting Commissioner Reinders, what I see, sadly, and it pains me to say it, but I see increasing disconnect between what I read in the reports and the reality on the ground. There is an increasing tendency to claim progress when there is none, or there is a tendency to claim progress when there is only cosmetic progress to the extent that a legislation has been adopted. So happy days, rule of law has been restored, when in fact there is no actual compliance on the ground. Now, I know it's not easy, and to be fair to the Commission, to do whatever they need to do to make the annual rule of law report meaningful and have a forensic assessment of the situation, they will need much more resources. But this is why, in a way, we need, in any case, this independent report to actually point at not only the macro gaps, but also the micro gaps in all the different reports. So I think hopefully the EU institutions would see that we're not doing this for the sake of criticizing the EU. We're doing this for EU's sake and for our own sake because of the authority of EU law. It directly simply not only affects us in the EU, but is affecting an increasing number of people externally. Now, I could go on and on in terms of what needs to be done in terms of upholding the rule of law better, more efficiently, and I would agree with regarding the use of interim measures, for instance. But as you said, in fact, yes, I agree. I mean, I would agree with my own assessment, which is we should stop creating new tools. I spent the last 10 years debating whether we need new tools. I would like to be able to now focus on whether the tools are being correctly used or misused. So this is the key. And I would recommend in this respect, actually, the criticism is not simply coming from us external to the EU institutional framework, but for the first time, and I think this is quite a breakthrough, the EU Court of Auditors itself has published 2 very good studies on the EU's rule of law toolbox and the way it was not used properly. So this is quite new. This is a breakthrough because the criticism now comes from within the EU institutional framework, and it is evidence-based. So it's not simply us believing in an expensive understanding of the rule of law, which is disconnected from real constraints. No, this is about consistency, authority, and at the end of the day, the legitimacy of the European construct itself. So it's in the EU self-interest to take into account our criticism. So that's it. I went way beyond the EU FRA question because I wasn't sure when I was going to get another question. So thank you for giving me the chance to expand beyond the EU FRA. Thank you.
I'm showing my bias. Petra, can I turn to you now?
If I may add something to the role of the FRA or the potential role of the FRA taking over this task from the Commission, we have long been advocating, and the European Parliament has actually long been advocating the involvement of experts into the process. And this is something that the Commission always rejected for various reasons, but we still argue in favor of it, because very often, if you cannot counter the criticism, then you will counter the critique. And this is what many member states are doing. They are saying the Commission, and especially the first Ursula von der Leyen Commission, claimed that it's a geopolitical and political commission. So then the member states which are being criticized are easy to say that, well, this is just a political attack against us. This is not a professional one. However, if you do include experts, then it would take away the edge of this argument. Also, this is not me saying, this is the European Parliament dissecting basically the most recent annual rule of law report, saying that, yes, indeed, now there are country-specific recommendations, which we all welcome, I think, because the main weakness of the annual rule of law report is really enforcement. So at least there are country-specific recommendations, where there are still no deadlines to fulfill these recommendations, and there is no enforcement, but at least they are there. But what the European Parliament is saying, that oftentimes the devastating criticism doesn't really match the country-specific recommendations. So that shows that there is some editorial work going on somewhere in the Commission for various reasons. So again, if there was an expert panel involved, then probably they could point at these discrepancies. And what we have also promoted a long time ago with Professor Pesch was the creation of an expert panel, of a network of experts, on the example of the network of experts of fundamental rights that used to exist with the chairmanship of Professor Olivier de Schutter. So we could create the same thing, and then it wouldn't be the experts who are doing the actual analysis, but at least their assessment would feed into the annual rule of law report.
Thank you. Tineke, could we turn to you?
Yeah, thanks a lot. Indeed, I remember 5 years ago, I was shadow on the rule of law report, where we also already urged for, the involvement of independent experts. And indeed, the Commission has been very reluctant to do so, saying we are the experts. So afraid that would be disputed. But also for the sake of transparency and neutrality, that it is important, especially also what Petra said, that for now, the way that the Commission is assessing to what extent its recommendation has been fulfilled is very subject to a lot of criticism. And I also noticed when I was, this is also regarding the benchmarks of the milestones in the RRF. And this is really problematic. When I was in Hungary, I was again confronted with the fact that the National Judiciary Council is completely circumvented and also subject to smear campaigns, although the installment of this council was a reason for the commission to defreeze part of the money. And the same goes for the Integrity Authority, which should combat corruption, but also this authority itself says, look, I really miss all the relevant investigative powers to do so. So it should be, the benchmark should be much concreter, but it should also, the reality in practice should be assessed and should be leading for concluding if something is fulfilled or not. And what we now try to do, at least with the upcoming hearings, also with McGrath, is to urge for improving the rule of law report if it comes to concrete deadlines, link it to concrete specific instruments that will, be sort of automatically triggered once the deadline are expired. So at least to have that part being safeguarded better, the part of the enforcement, but of course also take into account, as long as there's no independent panel, the NGO reports, because for Poland, for Hungary, NGOs draft a great shadow report on the rule of law report, which which needs to be taken into account while looking at what country-specific recommendations should be given. Maybe there was also a question on civil society, I remember. But maybe I can skip that if there's no time left. At least what I would like to say is we should, what I notice in Hungary, civil society is more and more under pressure. It's really urgent. They feel, that this deterrent effect is really taking place with the National Sovereignty Act, for instance, the smear campaigns. So I think the EU should do much more in order to, on the one hand, publicly speak out against these things. What Michel said, also coming up with interim measure request, but also regarding funding, give them more access to funding in a more direct way so that they can also survive and do their work properly. And also regarding, we now have this idea of democracy shield and a civil society platform, make sure that both are really serving and strengthening the position of civil society organization and not the other way around, so that they can be easily targeted as foreign agents because they are actually doing their work with EU-funded projects. They are actually serving the EU values instead of the other way around.
Thank you. Before I turn to Michal, I'd like to say that we only have time for one more round of questions. So please think of that burning critical question that you can say in less than 10 seconds. But in the meantime.
Okay, so I understand I have a very short time. But first, I need to make a short remark to what Petra said about the absence of external experts in the process of taking the decisions by the European Union institutions. This is true. I agree. But on the other hand, when it comes to the Polish process of devastation of the rule of law, experts were inside that process, but had to be very persistent and even pushy to be inside this process. We had to knock to the doors of commissioners to discuss with them, to present our expertise consistently throughout all of these years. And we were present. We were present in the Commission. We were present also in the Parliament at many hearings. Judges from Poland were very often present in the Parliament and presented their opinion. And also in that process, Polish external experts, but not only Polish external experts, fortunately, many international external experts, as you sitting here in the panel, were very much helpful in the process of the protection of the rule of law in Poland, using the institutions of the European Union. But I understand that, that there was a question about migration and the asylum, the question from my friend, an honorable judge from Turkey. Of course, I agree with you that it should be definitely the part of the annual report on the rule of law, because this is a very burning topic in the European Union right now. It has been, and it is, and still it will be during this term, one of the most challenging topic, especially after the new asylum and migration policy was presented by the Polish government, and is a hot topic when it comes to the debate inside the European Union. But yes, you are absolutely right. I agree with that, that it should be the part of the annual rule of law report. Thank you.
To our final round of questions before I ask for final thoughts from our panelists. But first I want to turn, we have a question over here, but I'm going to ask question over here first, and then I'll go to Voice of the Internet and then the room for final questions.
Hi, thanks, Jack Power from the Irish Times. Just a question on the incoming Commissioner Designate for Justice, Michael McGrath. What would be one thing that each of the panel would like him to see do differently than his predecessor? Thanks.
Thank you. You're reminding me I need to update my subscription. Johannes, over to you.
There's two more questions from the online audience. The first question, to what extent do you think the European Court of Human Rights can support the Court of Justice of the EU in the implementation and the control of the rule of law? And second, I think Laurent already touched upon that a little bit, how to strengthen the EU powers in protecting the rule of law if change of the treaties would be currently difficult due to unanimity.
Thank you. I think we have one more question I can take. We have two passionate people in the same row. I couldn't arbitrarily choose between them. You both got a question.
Hello, I'm sorry I can't stand up because of my computer and the limited space, but I'm Selena Bagumian. I'm a research assistant at the Institute for China-Europe Studies. I'm also a Belgian citizen of Armenian origin, so I have two questions about China and also the Armenia-Azerbaijan situation and the rule of law enforcement from the EU there. I would like to ask maybe Professor Pech, you might be more adapted to answer my question. So in regard to Armenia and Azerbaijan, do you think the European Union really uses the tools effectively, or if they are not sufficient enough to solve the issue between countries and to try to keep Azerbaijan to respect the rule of law and human rights and other international rights more effectively? My other question is about China, and I saw a press release from the European Parliament about the Taiwan-China issue. Again, do you think that the tools used by the European Union on the international sphere are effective in these cases? Because it doesn't seem to dissuade either Azerbaijan to leave Armenian internationally recognized territories, nor China to leave Taiwan alone. So thank you very much.
Oh, yeah. Thank you very much. And my question is relevant with this lady. So my question goes to Mr. Member of the European Parliament. So basically, my name is Redang, so I'm an academician. In the past 4 years, was in Central Asia, so just to the east of the Azerbaijan, several Central Asian countries, and I'm in Brussels because I'm suffer a lot of human rights violations in Central Asia. And myself is actually a victim as well. I'm here because I'm also expert for European Commission and also expert for WHO in the past few years. Okay, so I just wonder that whether European Parliament would have the agenda to also to care for the human rights, the human rights situation in Central Asian countries, and in future would have some more active step to support the construction of the rule of laws of Central Asian countries. under the background that the strategic partnership between EU and Central Asia is currently strengthened. Okay, thank you very much.
Thank you. So strengthening rule of law and partnerships in Central Asia. Thank you so much. Lest Professor Pesh worry that I'm trying to ignore him, we will go to him first so he can answer as much of that as he wants.
Can I select the questions as well that I wish to answer, and those I don't want to answer, I can leave to the rest of the panel? No. So I'm going to answer the question from the Irish Times journalist, and I also need to renew my subscription. I would say if I had any advice to offer, I would say it would be to stay away from any kind of a tool creation. So focus on making the best use of the existing toolbox and focus on enforcement. And I would focus here in a very specific aspect, non-compliance with judgments of the Court of Justice. And why is not the Commission using the tools available to it to actually sanction to what is the most basic violation of the most basic understanding of the rule of law, when you have member states or even sometimes EU institutions disregarding the case law of the Court of Justice? I think we're facing a serious rule of law issue here. Regarding non-compliance with ECJ rulings, we find ourselves in a very paradoxical situation where essentially non-compliance with the judgments from the Strasbourg Court are detailed in the Commission's annual rule of law report, but we have no assessment of non-compliance with judgments from the EU court. So this is a bit, I never thought I would see the day where essentially we have an EU tool focusing more about non-compliance with judgments from a non-EU court than non-compliance with the judgments of its own court. Now, I'm saying we need to do both. Now, I think I understand why the Commission would be reluctant to focus on non-compliance with ECJ rulings, because if the Commission were to admit that judgments are not complied with, then it has no discretion. But in fact, I would argue it is under a strict legal obligation to bring an enforcement action against the relevant member state. Now, this brings the broader issue of the EU's system of remedies. And just to keep it very short, if you are in a situation where the EU institutions are violating rule of law requirements, and the EU institutions are all complicit in the violation of the rule of law, then legal standing becomes the key rule of law issue. And currently, it's very difficult for natural and legal persons to actually bring annulment actions against the EU when the EU itself is violating the rule of law. I've been acting on behalf of police judges, for instance, and we are struggling to get heard in the Court of Justice. There is also the broader issue of when the EU institutions are refusing to enforce EU law against a specific member state. Then you cannot force the Commission to bring enforcement actions. So then the usual typical answer since the 1960s is, it doesn't matter because you can always go through the national judicial system, except that this was true pre-backsliding era. We found ourselves in an increasing number of situations where the EU institutions are not acting. And the only way to reach the Court of Justice is to go through a national system, which is no longer operating independently. You may still have brave judges, but a brave judge submitting a rule of law preliminary ruling request to the Court of Justice, this is equivalent to committing professional suicide. So we're reaching a stage where essentially we have major accountability gaps because you cannot have a day in court in Luxembourg, you cannot have a day in court at the national level, and then there's nothing else you can do because and then you can say Strasbourg court, but then autocrats have found ways to actually delay your day in the Strasbourg court as well. So essentially, the bottom line, and it's quite depressing, is that you can get away with systemic rule of law violations in the current framework for many years. And I'm just going to answer one final question. I won't be able to answer the Armenian-Azerbaijan question beyond my area of expertise. I mean, I know like a typical citizen, but I wouldn't claim any expertise, so I'm not going to answer this. But I do have a bit of expertise on EU-ECHR relationship. There's something new, which is positive. The Strasbourg Court is paying increasing attention to the case law of the Court of Justice, but that's not brand new. What is new is that I have at least two examples where the Strasbourg Court found a violation of the judgments and orders of the Court of Justice when the Commission was arguing they were not violated. So this is quite interesting. I hope we're going to see this more and more. Essentially, the Strasbourg Court kind of protected in a way the authority of the Court of Justice rulings on the back of individual complaints decided on the basis of the ECHR. At the same time, the official position in Brussels was these judgments are perfectly complied with. So just to give you an example regarding Poland's disciplinary regime for judges, there was an interim measure. At some point, we were asking for the Commission to go back to the Court of Justice and ask for financial sanctions. The official line was there is no need because the order is complied with. It wasn't, according to me. But there's nothing you can do, again, back to the accountability gap. But then a year or 2 years later, the Strasbourg Court said this interim order of the Court of Justice was never fully complied with, even though the guardian of the treaty stated a different position. So essentially, you can see there are plenty of accountability, but also enforcement gaps in the current EU system, because we didn't design the system to deal with backsliding, bad faith authorities. So this is where we're struggling a bit. We have always assumed that we wouldn't be facing systemic non-compliance with basic EU rule of law requirement. And yes, this is where we are. And you don't need to ask me any more questions. I know I've exhausted my time. Thank you very much.
You could see it in my expression. Petra.
Thank you very much, and thank you for taking me a second, because it actually complements what Laurent said about the first two questions asked. It's very interesting, I think. I agree, Laurent, that the European Union is protecting kind of ECHR decisions, and at the same time, the ECHR is protecting European Court of Justice judgments. It's interesting to see. Now, if you ask for recommendations, I think this is the last minute to have EU accession to the ECHR. We already said this, but we already have decisions where the Strasbourg Court held that member states, when complying with EU law, violated the European Convention on Human Rights. And this is the last thing we want, to have a split in the general European human rights protection. Also, the Strasbourg Court has a very forward-looking understanding of judicial independence, oftentimes giving more protection to judicial independence than the Court of Justice of the European Union. So that should certainly be harmonized. Professor Kochanov and I have several articles just showing how many standards, judicial independence standards, the Court of Justice of the European Union is actually using, which goes against the concept of judicial independence very often. And it's just it's not only within the Luxembourg jurisprudence that it should be harmonized, but certainly also with the Strasbourg jurisprudence. With regard to the Justice Commissioner's role, I would want to see the Justice Commissioner pushing for more cases. Our colleagues, Professors Kellerman and Pavone, have shown that there is a decline in infringement proceedings, especially with the rule of law element. So there are disappearing infringement cases. So there should be started very often. The argument that one gets from people in the Commission is that it would be very problematic for the Commission to lose a rule of law related case from a diplomatic perspective, which might be true, but with all due respect, the role of the Commission is not to win cases, but to be guardian of the treaties. So start the cases, define the rule of law cases as rule of law cases, accelerate, prioritize cases, use interim measures, and then have enforcement of these cases. Then there is one more suggestion, which actually goes back to the very first question from the internet, and this will be my final sentence, and that goes back to the annual rule of law report. So I think that the Court of Justice of the EU made passed a very important twin judgment with regard to the conditionality regulation when Hungary and Poland attacked the conditionality regulation. And there were many important points, but one important point is that the court distinguishes between sanctions and legal consequences. And it says, yeah, certain issues are just not sanctions, but we have to attach legal consequences to a negative finding in the rule of law in order to keep up the European project. And my suggestion for this incoming Justice Commissioner would be to attach such legal consequences to a negative finding in the annual rule of law report. It's not sanctioning, but we should think about, is it a good idea for a member state to hold the EU presidency where there are several red lines crossed with regard to the rule of law? Is it a good idea to force judicial authorities to still trust the courts and the judges in a member state where there is judicial capture? So my suggestion would be, if a red line has been crossed and it has been proven by the Commission in the framework of the annual rule of law report, then mutual trust-based laws, for example, should all be suspended and should only be reinstated when the next annual rule of law report finds that the member state in question is already on the right track.
I'm going to leave the very last words to our two MEPs. First, Michal, and then Tineke, you're getting the very final word of this event.
Very short answer on a question related to Central Asia and other parts of the world where the violations of the rule of law and human rights protection, these topics are, I think that there is a quite broad space in the European Parliament for these issues, especially in LIBE committee. We are creating also intergroups like democracy intergroup, where you can find the space for these issues. So I think you should file the motion through the European political groups for the hearing or for exchange of views related to the issues that you are interested in. But second question related to Michael McGrath and his future job, especially when I had a chance to talk to him about potential challenges for him in the future. On the contrary to what Laurent said, I think that I would encourage him, and I will do that, to start the debate about improvement of the toolbox in the European Union, because I think that even if, of course, I agree with that the European Commission should perform their duties accordingly to the role of the guardian of the treaties, and they should react very quickly, as I said previously. But even if the Commission is performing their duties accordingly, it is not efficient enough to protect the rule of law in Europe, in the member states, because it appeared last year that only a strong financial instrument are effective to stop the violation of the rule of law. We had actually accidental instrument which was blocking the recovery and resilience funds in Poland, and that was the most effective tool. So I think we should start the debate about potential conditionality mechanism which protects rule of law as such, not only protects the budget. And of course there are other ideas how to improve this toolbox, but I think that we should start the debate about it. Thank you.
Thank you. And finally, over to you.
Yeah, thanks a lot also for the questions. Actually, it's clear that McGrath gets different signals from the different members, the MEPs, because my message was more like, please don't be distracted by thinking of new tools. Although I really understand what Michel is saying, rule of law as such should already be a basis. But I think what is the biggest shortcoming is the political considerations that come along with the decision whether or not to enforce. And I think that the toolbox is quite full already, and that it could be applied in a much more effective and consistent way. Even also the conditionality mechanism. What we ask McGrath is also for an extensive interpretation of that. So, and make sure that there's sort of automatic use of a conditionality mechanism in case of non-implementation of judgments of all European courts or landmark national judgments. And I think then already rule of law could be protected better. I already referred to the rule of law improvements that we would like to see from McGrath, but also indeed, as Petra said, a much more consistent use of the infringement procedure, including interim measures. And in order also to push for that, I also try within the Jury Committee to get a majority for joining the case on the National Sovereignty Agency, and also push for an interim measure there. I think the European Parliament should also become more active in the litigation part as well. Regarding Brunner, because actually van der Leyen said in the mission letter to all candidates that they should step up enforcement. So I think that the European Parliament should really use the hearings in order to get clear commitments on that. I will do that also with Brunner, so also more enforcement regarding migration. And in his mission letter, there's also said that he needs to ensure fundamental rights compliance in the external dimension as well, and parliamentary scrutiny. So I also said to him, we need to see tangible commitments on that, because so far it was completely lacking in the previous commission. And maybe one thing on the external dimension, it's true what Laurent Pech said, that the FRA mandate is too limited. It cannot step over, it cannot deal with the external dimension. Although I think you could also, be more creative as long as the mandate is not formally extended. The EU Ombudsman, for instance, does it. It's not so long ago, it came up with a recommendation regarding the migration deals, that there should be impact assessment prior to that. So I really hope that both FRA and the EU Ombudsman will stay proactive in, in engaging with what the EU is doing also outside of the EU. But of course, it should be also upon us to make sure that this mandate will be strengthened.
Many thousand thanks. Before I go through the litany of thanks that I'd like to offer, can I just mention, we have so many copies that I would warmly encourage everyone in this room to take as many as they can hold. It is fabulous reading with a double espresso. I'm sure your mother would be interested in it. I know I'm going to give a copy to my mother. But I would now, on a more serious note, like to thank our fabulous and wonderful panel for coming today. Huge thanks to the European Policy Centre, who I'm going to pass over in a second, for hosting us.
You mentioned the contributors.
Huge and even bigger thank you to all of the contributors to the report. Some of whom are in the room. Thank you so much to our incredible contributors to the report. I suddenly realized I meant to be thanking everyone in the report too. Thank you also to the incredible co-editor that did this with me. Well done, Barbara. And thank you, everyone in the room, for joining us and asking these questions. If I've forgotten to thank you, I'm so sorry. Ask me for a coffee. On a final note, if anyone would like something bite-sized and quotable from the contributors to the report or the authors, just come talk to us. But for everyone else, I'd like to pass you over to Johannes.
Very briefly from my side, I prepared a full concluding remarks, but I think everyone is ready for lunch, so I spare you these words. I just wanted to give back the thanks to the CEU Democracy Institute for putting together this event. I think not only the report, but also the discussion that we've had today, concerning developments we've discussed, the politicization of the rule of law, but also the policy areas, which will all be on the very top of the agenda for the next EU leadership, highlights how important it is to have this kind of report and also to continue this work. So I really look forward not only in delving into this report, but also looking to the report of the next years. And with that, I conclude and invite all of you into the next room where we'll have a small lunch for everyone. Thank you, everyone, for being here, for the engaging discussions, and looking forward to see you soon.